My name is Catherine Rivkin, and along with my co-counsel Sadie Blanchard, we represent the 34 Tuban victims who've experienced anguish and distress as a result of Robert Turk's incitement to genocide. We have been asked to make submissions on all 4 points of the agenda. I will address the preliminary issues, that this chamber should confirm its preliminary decision to grant victims K01 to K34 victim status and participation rights, and that this court has jurisdiction, and my co-counsel will address the remaining 2 issues on the agenda. The 34 victims today are not concerned with the sections and subsections of the Rome Statute. To them, this case is about fear of dying and a threat to kill. These 34 Tubans are living in fear of total nuclear destruction because of Robert Turk's incitement to genocide. This court is a primary organ to open the door to victims' participation and to give victims a place at the table in international justice. The court itself calls the series of rights granted to victims one of the great innovations of the statute and the court. The court placed such a priority on victims' participation because its key goal is not only to end impunity for the most serious crimes against mankind, but also to grant participation and bring justice to those who have suffered at the hands of the accused, like these 34 victims. There should be no question that victims K01 to K34 qualify as victims as defined by this court. 2 criteria under Rule 85 are the key issues to clarify in these proceedings. The victims have suffered harm, and a causal link exists between the harm suffered and the crime of incitement charged. Both criteria are clear in this case. Our colleagues, the prosecution, acknowledged, and we emphasize that since
you just say both links appear.
I'm sorry?
Can you explain what is the first link? Because you say both links appear in this link.
Yes, Your Honor.
Expand on this a little.
Yes, of course, Your Honor. I will just now. On the issue of harm first, our colleagues, the prosecution, acknowledged that emotional harm is an acceptable form of harm for victims to participate before this court. And we emphasize that since its inception, the court has always recognized mental, emotional, and psychological harm to be sufficient and appropriate forms of harm to qualify an individual to participate as victim. Nearly every decision on victims' participation to date has included victims of emotional harm, and we don't need to look to the ICTR's decisions to note that fact. By way of example, the Lubanga Appeals Chamber clarified that harm under Rule 85 would include one man who was, quote, saddened by his military experience fighting Lubanga. The Abugarda Pretrial Chamber similarly recognized nightmares as appropriate forms of emotional harm, and also recognized, quote, depression as harm. Saddened, nightmares, and depression, these are all similar claims of emotional and psychological harm that these 34 victims claim before you today. Moreover, a single instance of harm alleged is sufficient. Since the very first decision on victims' participation by the pretrial chamber in the situation in the DRC, the court has held that, quote, a single instance of harm suffered is sufficient at this stage to establish the status of victim. This was most recently affirmed by the Abugarda Pretrial Chamber in its decision on victims' participation in October 2009. Moreover, a principle of this court is that at this stage in the proceedings, the court takes victims' applicants to be true on their face. The prima facie standard was established in the very first decision on victims' participation, and again was reaffirmed in the most recent decision in the by the Abugarda Pretrial Chamber. The Abugarda Pretrial Chamber noted that the applicants are only required to demonstrate that the 4 requirements of Rule 85 are met prima facie, and, quote, the analysis of the applications will not consist in assessing the credibility of the applicant's statements or engaging in a process of corroboration stricto sensus. This standard was upheld most recently for victims including those who claimed emotional harm, and nearly identical to the fear claimed by the applicants today, including anguish and sadness. The 34 human victims today deserve to be accorded the same standard applied by every chamber in determinations of victims' participation in the past. On the issue of causal link, under this prima facie standard, the causal link in this case is clearly satisfied. To determine causal link, the court must ask itself the simple question, can the harm be traced back to the incitement alleged? The learned defense counsel misstates that it is not that they allege nuclear weapons caused their fear. It is precisely not that. The causal link stated in the victim's applications is clear, that they have been living in fear of an attack of nuclear weapons ever since Robert Turk called for the destruction of Tuba, a statement that itself establishes prima facie that it is only ever since Robert Turk made those statements that they have been living in fear.
And say, despite the fact that this is an incomplete offense or crime, despite the fact that this is only incitement which did not lead to a real, like, as compared to this case we have just cited, Abugada?
Yes, Your Honor. We understand that the court may be apprehensive because this is a new charge for which victims are applying before the court. And we share the concern that when no act of genocide exists, that there is no direct act that has necessarily caused the fear. These aren't mothers who have watched their children killed in front of them and suffered emotional harm thereby. And we understand that logically under this standard, the 34 victims do qualify, and potentially the rest of the Cuban population may qualify if they make similar claims of fear. Article 68 requires that the court exercise some kind of gatekeeping function, but it also establishes that the unequivocal rights of victims to participate are clear. We want to ensure that we are able to most effectively represent meaningful victims of a grave act of incitement, Your Honor. And so for this reason, we understand that the court might choose to heighten the standard in the case of incitement. One way might be to heighten the prima facie standard. You might ask for corroborating evidence from family members of the extent of the fear or exactly how the fear was felt. However, whatever new standard the court chooses to adopt, we would respectfully request the opportunity to make submissions to meet that new burden. We are happy to make those additional submissions, and we are confident that the 34 Cuban victims would qualify under any new standard that the court imposes. But we would like to ensure their meaningful participation in the proceedings against the man whose incitement has caused them this harm.
Counsel,
Yes.
before you proceed, is your instructions to the effect that you want to limit yourself to the victim participation issue and not to the other issues?
No, Your Honor. I'll turn to the following three issues now, with your permission.
You will?
Yes.
Good. So we're getting apprehensive.
Turning to the other three submissions on the agenda, Your Honor.
Have you concluded on this one?
I'm sorry, yes. We proceed today on the other three issues of the agenda in keeping with the Lubanga Trial Chamber's decision on the manner of participation of the legal representatives of 16 September 2009. We understand our role to be distinct and different from the parties, and to assist the bench in its pursuit of truth and to clarify facts relevant to the personal interests of the victims that we represent. We therefore will not restate the arguments of the prosecution, but we have examined the law separately from the parties and will bring the victim's perspective to bear.
Good.
This court's promise to victims is full and fair proceedings to determine justice for the crimes under which they've suffered. Nothing about the issues of jurisdiction, immunity, or the testimony to be provided by Miranda Phoenix precludes this case from continuing to trial so the victims may see justice for the harm that they felt. On the issue of jurisdiction, we agree with our colleagues in the prosecution that this court has jurisdiction over this case. And we see that the court has two options. One, indeed, considering that we do not know where the interview occurred and that President Turk is not a national or state party, the court may rely on where the intended victims of the incitement reside. However, we agree that this may be one option, but to avoid any question that might arise, as the Learned Defense Counsel noted, about whether effects was accepted or rejected at Rome, we also respectfully submit that the court should strongly consider a strict analysis of the words of 12.2a, that the conduct in question of